only, so you have to make an application, and in any country where you have to make an application, it takes time to process that application. In the meantime, you don't have any rights. And therefore, it's not a solution to the problem that we'll face on the 30th of March, for people to say, well, as of the 30th of March, you'll be third country nationals, you can start the process of applying for rights under this directive or various other directives that give people the right to apply to be in the EU. Another reason why action has to be taken now. All the various EU directives on the rights of third country nationals, even put together, do not give you a comprehensive system that guarantees all your rights. They tend to be one-offs that apply to one group here and another group there, but they don't give you a comprehensive set of rights. So I can't look at you in this room and say, don't worry, if they pass a law to say we're all legal third country nationals on the 30th of March, all your rights will be there. It will depend on who you are, why you came here in the first place, under what you're doing now, and a lot of other things. So it's not a comprehensive system of rights. And the other thing which I should say is this: in order to qualify at all for that particular directive, which is probably the directive which would be of most use to us if we're in a situation of having no other rights, is that you have to have been resident for 5 years. But your periods of absence, permitted periods of absence from the country during those 5 years, are much more limited than they are for your ordinary EU residence rights or your ordinary right to soggiorno permanente. If you've been out of the country for 6 months consecutively at any time during your 5 years, or for a total of 10 months during the 5 years, then you will not qualify under that directive. And the 10 months is the killer period, because quite a lot of people will have spent quite a lot of time away from Italy thinking, well, it's fine, I've retired, whatever it is, I can travel a bit, or I can go and see my family, or I can spend a lot of time with someone I need to spend time with, and might have lost their rights by doing that. My wife and I have totted up our 5 years. We are very, very close to the limit, and we're not leaving this country till after Brexit, because we're very, very close indeed to the 10 months. And we haven't spent, exceptional amounts of time in the UK. I think those are the main things I wanted to say about the third country national point. The only other point I should mention is this, which is mutual recognition of professional qualifications. There's some good news here, which applies deal or no deal. Both sides have issued statements on what would happen in no deal. And both sides have said that if you have a recognition decision, in other words, if, take our committee member in Rome, she got a decision from the Rome Bar, we recognise your rights as an English solicitor, you, and coupled with the training you've done in Italy, you can now practice as an avvocato in Rome. That was done before Brexit, before the end transition. So those rights will be recognised and they're fixed. I think they're fixed not because of any agreement that's been made between the EU and the UK, but simply because as a matter of law they recognise that is the effect of the decision they've already made. So those will stand if we've got a recognition decision. I can't say the word even in English. Before the 30th of March, that will stand. In most cases, one or two of them don't, but they're quite specialist professions where it doesn't help. The UK at present has done a lot more than Europe to protect the rights of EU citizens in the UK. They get a pretty bad press about this, but in fact they have in force at the moment a law which continues EU rights after Brexit. The same law entitles them to take them away, but they haven't done that. So as at the 30th of March, EU citizens living in the UK will not be illegal migrants. They will have some rights. What the UK has done instead is to issue some immigration rules which are already in force and which are to regulate the system of applying for settled status, to give people a regularised status after Brexit. That is already undergoing application as a pilot scheme and will be rolled out in due course. And the intention of the UK, as far as we can tell, is that even if there is no deal, they will still continue to operate that system. They haven't been entirely clear on what should happen if no deal. The Prime Minister's made a statement, a very short statement, with some reassuring words. but the full extent of the rights which will be available to EU citizens in the UK after Brexit is not clear. That they are a step ahead of other countries in the sense they've got something, and the default position is those rights remain until they're taken away. France, as you may have seen or may have read, has prepared some proprietary legislation. Germany has done the same. Italy has not done anything at all yet. Which brings me on to my final point, which is ring fencing. The rights that I discussed at the beginning as having had preserved by the withdrawal agreement include interlocking rights, such as the system for reciprocal aggregation of pension contributions, and for healthcare. It's not enough for any one country to say, we'll give you this, because it depends upon the cooperation of the other country. And so for that reason, any system that will truly give us something approaching what we have now by way of rights needs to be mutually agreed. And there is not time for the UK to make bilateral agreements with 27 different countries before next March. The obvious solution to dealing with our plight on the 30th of March, and it is applied, is to say, let's ring fence the agreement we've already made. It took a year to negotiate. It was a lot of hard work, but we have come to an agreement on this. Ring fence it and say that will be a freestanding agreement which operates if nothing else does. There are various technical legal reasons why that's the best solution as well. It's much harder to, it's much easier to get it approved than if you make separate bilateral agreements. And it is just the obvious solution because they've agreed it already. People have said from the outset, both sides have said, you, the citizens who've already moved, are the ones who are going to be our first priority in this negotiation. Well, first priority in the sense they talked about us first, but we're still in limbo and without rights at present, so it's not much of first priority as far as I can see. That's the first thing we would really like. The other reason why ring fencing would be important is because it also makes the rights enforceable as a matter of international treaty. Whereas if the UK says you can do this, if Italy says you can do this, they're all gifts, and gifts can be taken away. If they're entrenched in an international treaty, then that can't happen. We have pressed very hard in Brussels and London for ring fencing, and we have invariably met with the answer, we don't want to talk about it now because we're trying to get this deal through. And if that doesn't work, then perhaps we'll think about it. But no commitments, no discussion, even as a fallback situation. And our answer to all of those people has invariably been with primo levi, if not now, when?